Hi, how would you like it if I told you that if you are an employment based green card applicant, you may not have to file for a PERM? If you're an EB2 category, you may not have to file for a PERM. How would you like that? Me personally, as a lawyer, I would love it. And I'll tell you, this just came out recently. So far, the only people who did not have to file a PERM were physical therapists and nurses, and they came under a category called Schedule A. Now, when you're filing for permanent labor certification, that is governed by the Department of Labor. USCIS has nothing to do with it. What's going to happen here is that basically, like how nurses do it and physical therapists do it, the Department of Labor has decided there are not enough people in the profession. There are insufficient US workers who are willing, able, qualified under the regulations. So these people are referred to as Schedule A. Now, Schedule A has two parts. One told you about is physical therapists and nurses. And the second part is immigrants of exceptional ability in the sciences of arts. Woohoo, I'm super thrilled about this. Of course, let's see how immigration is going to go and adjudicate it. That's a whole different ball of wax. But at least now there seems to be some movement on the behalf of Department of Labor to open up the number of professions where they've finally determined there are not enough people. The federal government has come out with all these new acts that will require the CHIP Act and the IRA and everything else that requires lots and lots of technically qualified people. Even construction industry also needs a lot of qualified people because the construction runs on tech just like everything else. So finally, we have some movement in this direction. So the way it will happen is you have to be employed. So you can't, this is not a self-employment kind of a deal. You have to be employed. Your employer has to file for you. They have to attach a whole list of documents saying how fabulous you are, internationally acclaimed. You are in a society that requires entry level is very, very high. For instance, one of the associations that comes to mind is IEEE, which is an association, International Association of Electrical Engineers. You actually have to take, I hear, some kind of entrance exam or be recommended before you can join. So something like that, I think, would be what I would say would be a fantastic qualification. For other people, there are other professional societies that probably require the same thing. You'll see a lot of parallels between the O visa requirements and the Schedule A Group 2 requirements. They look similar, but they're not the same. They both are called exceptional ability in the sciences and arts. But do not forget, one is Department of Labor regulations, which is Schedule A Group 2. And then you will get a prevailing wage from the Department of Labor for your profession. Then you will fill out the permanent labor certification form. You will not be filing it online. You will be filing it with the USCIS along with your I-140. And if you're a person who's from a country where the priority date is current, you'll also file the 485 and accompanying documents. Once that packet is sent, you have to ensure that you actually qualify for more than 2 of the 7 requirements for the ability to file under Group 2 of Schedule A. You can read about this on uscis.gov. We have not filed any so far. We are hoping to file this soon for many of our clients who are very, very qualified, but our PhDs, which I think who are in AI, I think that would be a very good, excellent fit. So some of the things I want to talk about, okay, some of the requirements. Remember, employer sends these documents, not self-employed. Remember that. Internationally recognized prizes, membership in international associations, published material in professional publications, participation in a panel as a judge or in the same field or an allied field of specialization, publish scientific journals and scholarly articles, especially if you're a Google scholar and have lots of citations, that would be great. If you are an artistic person, you have your international acclaim, that means you have been exhibiting in more than one country. This is only for people who are not in the performing arts. If you're in the performing arts, say like a Broadway actor, and you come over from London to here, and then you want to file for a green card, this may be a way to go. You can talk about your performances in London or Paris or any other country. You have widespread acclaim, international recognition, that there are lots of articles about you on TV and video and periodicals and trade journals. And you're very high earning, very important. You have star billing. And then you have a list of concerts and theaters and nightclubs where you're scheduled to appear or have appeared. And you are a member of a theater or repertory group, company, ballet company, orchestra, and other organizations where you have performed or been, and all this has to be in the past year. It can't be 5 years ago. It has to be very recent and very close by. Some other things that you might want to think about is that while USCIS and DOL both say exceptional ability, USCIS will adjudicate it slightly differently than Department of Labor. You have to meet the Department of Labor standards, but you're filing with the USCIS, who's actually finally going to adjudicate and decide whether you are eligible or not. I expect a lot of RFEs in this area until it's a little more defined, and a lot of confusion on USCIS's part. But we are in the, this is like Star Trek, we're the final frontier. Let's go push it and find out and see where we can go with this. Thank you very much for listening today. We'll see you in our next video.